Thanks for joining us here on PM Express. Tonight, it is a massive controversy. Rarely do you have a sitting High Court judge go out into the public and make a pronouncement such as the Doma Hene made when it came to the Gyakye Quayson trial. And we're seeing this division play out between the court of law and the court of public opinion. Why are we having this conversation? We're having it because this conflict is one that the Ghana Bar Association just last week, when they marked the 41st anniversary of the killing of the 3 judges, was a central piece in the Ghana Bar Association's admonition of members of the fraternity, really. And then we've also seen going into this week the Attorney General complaining that this deliberate pitching of the courts against the public is undermining the administration of justice. But as far as the Gyakye Quayson case goes, it is a comment of the Doma Hene, who, by the way, doubles as a High Court judge, that has really elevated this to the realm of one serious issue that needs a bit more probing. What did he really say? Watch.
Supreme Court, yes, sir. Yeah. Yamubi no krenim ben kasa de same o Supreme Court kasa gina ye no kame me collect kame ko right na nenti agame ko no wan hwe no ane bedi sa asem ye wo ntimi nkoka bi na mo mesra and the Attorney General of Ghana.
Recently, the Supreme Court decided to annul his election as a member of Parliament. To be very honest, if I was on the Supreme Court, I would have dissented in that matter. As for the reasons I would have dissented, the matter is still in the courts, so I'll not go into details. But I'm pleading with the Attorney General. The law allows him to end such prosecutions when the public are against it.
Majority no 57.56 or as a matter of urgency, I'm appealing to the President of the Attorney General, President of the Republic. If he has any role to play, that trial should be aborted. The Attorney General should, as a matter of urgency, file a NOLLE PROSEQUI to end that particular decision. Sir, make a way because that was what you did the Ghana for attempt.
The voters have overwhelmingly endorsed the gentleman. 57% is not a small feat in an election. I am saying this because if we continue, it will be an insult to Ghanaians and the people of Asino.
Ghana for a juma a mampuntu akwa. No better my blame. It's on this day. Now my country says, Samri, you are president. You know I love you. This matter cannot go on. Attorney General. Odame, but I had the share, not the share. Shawumum Coco Chasem, if you are him as Ghana for.
So where do you draw the line between what is accepted when critiquing a judgment, for example, but what about when the case is live before a court of competent jurisdiction like the Gyakye Quayson one, especially when it comes from a sitting judge who doubles as a chief as well? That's where the line is being, people are trying to draw that line, and it's becoming a bit more difficult to do because of all the high-profile individuals involved. But this is not the first time such comments have been made about this particular case. The president himself was recently accused of doing same, and as we've seen already, the comments, as you've just heard there, has been criticized by many. But there's some also who believe he did nothing wrong. And one of the first to go out with the gravitas it comes to this with is Sambo Kudeto, who, by the way, is a member of the General Legal Council, and he actually goes ahead in his comments when I spoke to him yesterday, calling the comments you just had there senseless and wrong. And Sambo Kudeto is a senior lawyer in among the fraternity. member of the General Legal Council. He's a member of the General Legal Council Disciplinary Committee as well. And he's made that pronouncement. He says he should actually resign or be sacked. Very strong indeed. We've also heard from the Ghana Bar Association spokesperson, who also backs the call for some action to be taken on the back of the comments that we've just played for you, and that the Domaheny suggestion of halting the prosecution is inappropriate. We'll tell you very soon, really, if the Attorney General want to go ahead and halt the prosecution, can he do so, and through what means? We'll talk about that very soon. But then the Ghana Bar Association spokesperson makes the point that the Attorney General has also power to file another PROSEQUI. That is the process, and we'll tell you what it is. If the Attorney General is really considering doing that, as has been urged upon him by the Domaheny and others, that is a process that he will take. We'll get into the details of that pretty shortly. But in the wake of the comment from the High Court judge who doubles as the Domaheny, some have also pointed to previous comments during the campaign of Sin North by elements within the governing New Patriotic Party. The president himself had come in for some criticism when, on the campaign platform, he had actually said that what's the point of voting for somebody who will end up in jail, right? And that has been criticized as almost a prejudicial comment coming from a sitting president. So that's not the first time we've had controversy around this same case coming from high-profile individual in this particular case. It doesn't get as high as the president himself on the matter. Of course, John Mahama also waded into this and criticized the president for making that point and insisted that the narrative that Gyakye Quayson will be jailed is a lie. So as you've seen, this case has been front and center, obviously fueled by the Asin North by-election. That is the context within which this has become such a divisive issue, a hot political potato. If you listen to the Domaheny there, he places it within the context of the by-election. And he says that now that the people in Asin North had overwhelmingly voted for Gyakye Quayson, if you continue the trial, there'll be an insult to those people. But really, is that really the case, considering that this is before a court of competent jurisdiction, right? And that's the key thing that we have to understand. And today, the Attorney General himself has been raising concerns. And this is the bigger conversation that we've invited to have on the back of the Attorney General's comments today, also on the back of the comments I played at the beginning. And he makes the point that commentary such as we just had there interferes with the prosecutor's work and also pressures the court. Remember that the judges, they are also human beings. There is a judge that is sitting on the Gyakye Quayson's case. What does this do to that judge? That judge has a family. He possibly watches television. And if you hear a colleague, High Court judge makes that pronouncement, what will that do to that judge, to the judiciary itself? And the Attorney General is inviting us to be cautious when we are making pronouncements such as we just heard there. He also said in a statement today that he also exceeds the freedom of expression limit. The comments that we've been hearing about this Gyakye Quayson case, but also the Opuni trial, that's the Attorney General's view, that it exceeds freedom of expression limit. That's it, really. We'll get a view from our panelists when they join us. Also, the decision to prosecute is based on evidence and not political standing, and not regardless of your position and standing in society. Attorney General argues that when he's making a decision to prosecute, he's not looking at that standing. He's not looking at whether or not you are a member of parliament or going to contest. It's simply, is there the case? Is there the evidence to do so, to prosecute? And he asks the public to respect due process and avoid prejudicial comments. And in that context, many look at that and say, but if that is prejudicial, what about the president's comments I showed you earlier? And so we had the field, it has to be level, and the criticism has also to be fair, as those who read the Attorney General's point and raise the additional subject of being fair in dealing with this particular matter. And then, of course, it goes without saying, stating the obvious, there's no immunity when it comes to prosecution and in the administration of justice. But if you interfere in that, there will be no immunity for you, and then all persons are really equal before the law. So another thing I really want to do for you, and I know many of you watching tonight want to understand really what is the case against James Gyakye Quayson in that criminal trial, which has become such a major subject of controversy. So there are 5 charges against him, 5 offenses that the Attorney General has brought in court against him, criminal charges, 5 of them. And the Attorney General lays the plan in terms of when those offenses allegedly were committed. The first one I want to bring to your attention is allegation of forgery of passport and travel certificate. And Attorney General claims that this was committed on the 29th of July, 2019. And by the way, it carries a maximum of 2 years if he is convicted, right? And I'll tell you, this is actually the least of his concern, because there are others like this particular charge of deceit of public officer on the 29th of July 2019 that carries 3 years. So incrementally, you're beginning to see it beginning to add up if he is convicted. And then if you come to the 6th of October, and this is a critical time in this whole timeline, and this is one of the key allegations against him in court, that he knowingly made a false statutory declaration on the 6th of October as he was filing to contest the Asin North seat, that he was not a citizen of Canada when the Attorney General claims he was indeed a citizen and held a dual citizenship. And then you come to the 6th of October on that same day, and this is the big one, the allegation that he perjured himself, and perjury upwards of 10 years. So this is no joke what James Gyakye Quayson is facing at the High Court. If he's convicted, that is what he's facing. And the president has said that, what's the point of voting for him if he's going to go to jail, for this much, for this long, if he's convicted. And he is innocent until proven otherwise. It's a very important point that you need to observe in talking about this. And then there's the final one, false declaration for office. Again, carries a penalty of for 3 years upwards, and this, the Attorney General argues, was committed on the 8th of October. So this is the spectrum when it comes to the charges that he is facing. And now you begin to understand why there's such a big public, controversy surrounding this, because it's not a civil case at all. It's not about whether you qualify to be an MP or not. This is about, your liberty. His liberty. And also, we know that Quayson has filed, processes now to challenge this, right? And he argues in the court that the court made errors in law in ruling that this should be heard on a daily basis. And lawyers have alleged political turn in this whole case. They're making the case that President Akufo-Addo's comments were prejudicial, and it's now before the court for consideration as well. And understand that will be played also. And Quayson seeking to file for stay of proceedings as well in this. Right? And so this is going to be fought quite hard. And today, he was sworn in Parliament. In the midst of all the controversy, he has been sworn in. He's now formally a member of Parliament for Asin North. And if you look at the votes that he polled there, significant votes if you compare to last 4 years. Well, 2020, not even 4 years yet, 2020. So this is significant, right? In 2023, 57%. If you go to 2020, 55%. So he's increased his votes. And that's what Domahene is making, that if you look at this overwhelming victory compared to the MPPs now, the people are actually making a statement. And he believes it is in the interest of us all for the state to just back off from this. So the key question that many of you have asked is, so there's a pressure on the Attorney General to stop the case, terminate it. How can he really do that? He can file a NOLLE PROSEQUI, for example. And what is it? It's a decision not to proceed with the case. That's what this big word means. How can he do so? He can enter NOLLE PROSEQUI at any stage of a criminal case. So it's not too late for him to do so. And this is according to law, by the way. He can also either state it in court or inform the court in writing. He can come to court on Thursday, which is the next hearing date, and say he no longer intends to proceed with this matter, and the case would have ended, right? And then he can also write it to the court, not being there himself. Somebody can go and read to the court, and the judge's attention will be drawn to it. Now, the accused is immediately, if this happens, the accused is immediately then discharged or released when this happens. So what will mean is Gyakye Quayson, once that happens, immediately he will be discharged. But here's an important point. Yes, he's been discharged, but it does not prevent subsequent proceedings against them in relation to this same case. So although this can be done, right, legally, the Attorney General can still go back years down the line, months down the line, and say he wants to go back and prosecute this case. And by the way, it is the Section 54 of the Criminal and Other Offences Procedures Act 1960 that breaks this down. And so for those of us who are not lawyers, who are wondering, why are they asking the Attorney General to do so, and how will he do it? This is how he can do it. I'm going to return and have a conversation with my panel as well. There are bigger questions about this. There's a question about, why this has become such a political hot potato, but also the legal issues that has come up about commentary on such matters, and why a certain judge, the prudence, the propriety of that. And then this is now playing out in Parliament today. The minority side have said they won't be participating in parliamentary business on days when Gyakye Quayson is before the courts. So really, what should happen going forward? This is not having to do with the live case, but everything that is happening around this in Parliament and the public that needs some form of resolution. On the back of the Attorney General's comments. So stay with me. After this, my guest will sit and we'll have a conversation. And PM Express is always brought to you by Cherry Tree Properties. We develop spaces as though we were going to occupy them ourselves. Syntax, it is strong, it is tough. Alumo Bitters, experience greatness in every moment. And the Ghana AIDS Commission. And as you know already, no matter your water needs, Syntax Tanks has it all for you. Syntax Tank is first to introduce the double layer tank, and now you can have as many layers as you want. Syntax Tanks is first to introduce white inner layer tanks in Ghana. We now introduce to you the customer specs order, which lets you order any color and size of preference. Syntax Tanks gives you the longest warranty of 7 years, which no other tank gives you in Ghana. So whatever your water consumption, size or project or demand, choose Syntax Tank. We have agents nationwide. You can call us on 0244 335 168, 0244 335 168, or shop online at syntexgh.com. Syntax Tank, a strong, a tough. And also, you know that desires are wishes. Beauty is a promise of happiness, but passion is everything. You're thinking about buying a new home, you have to talk to those who build with passion. That's the Sloan Square. Is a new gated community development at Sakumono and developed by Cherry Tree Properties, one of a kind, well-planned luxury you've never experienced before. You have to call them on 055 33662 366, 055 36662 366. Sophistication and class. With me in the studio tonight is Professor Stephen Kweku-Asare. He's a professor of, as you know him, the KPMG professor in the Accounting and the Fisher School of Accounting. He is, of course, a CDD Fellow, Law and Justice at the CDD, and we're grateful. And that is why he's here, Law and Justice, really. It's a conversation that we've been having for a while, but now it's been thrown into a different level, I think, with the commentaries that we've seen in the past few days. Prof, thanks for your time.
Thanks,
on PM Express. And of course, Roxing Nelson Dafiamepo is a member of the Constitutional Legal Affairs Committee in Parliament, and he joins us in the studio as well. And we had reached out to the governing party and to the MPs in the House to try and get them to give us some perspective. The party actually assisted us at one point, but we were unable to get the individuals who we had reached out, and the party also facilitated for us to join. And so we'll have the conversation nonetheless. Prof, I want to start with you, and I want to start with you as your brief overview, reaction to all that has played out in the last few days since Asin North in respect of Gyakye Quayson, but also, I guess, the most controversial one that has thrown this really up in the air is the comments by the Domahine. I mean, what's your reaction to everything that has played out?
Well, thanks, Evans, and fascinating developments. First of all, let me congratulate the Asin North MP. I noticed today that he swore an oath of allegiance, and not to relitigate the Supreme Court issue, but I want the nation to be clear that the oath he swore today had nothing to do with citizenship. It's a job-related oath of allegiance, and that's what Article 94 2A is all about. when you swear that oath of allegiance, it is serious business, because unlike citizenship-related allegiance, this type of oath is juridical in the sense that if you violate the oath, you will be removed from office. But even when you are removed from office, you continue to be a citizen, because as I've insisted, allegiance and citizenship are never the same thing. Citizens owe allegiance, but it doesn't mean anytime you see allegiance, then citizenship is implicated. In constitutional law, allegiance to a country other than the country in question is a term of art that basically refers to occupations. So we start with a problem at the Supreme Court, but let's move away from that and get to the criminal assize. What is at stake in the criminal assize? We are told by the government that when Gyakye Quayson answered the question, do you owe allegiance to a country other than Ghana? When he answered no, he knew that he was providing a misleading response. Gyakye Quayson, on the other hand, responds and says, no, I answered that truthfully because to me, the question meant, have I renounced my citizenship of Canada? Have I applied to renounce my citizenship of Canada? The government says, no, that's not what the question means. That question means, are you a citizen of a country other than Ghana? And the Supreme Court steps in and says, guys, stop playing. This question of do you owe allegiance to a country other than Ghana is inherently ambiguous. It's vague. And so we are going to step in and tell the nation what that phrase means. Now, let's think about that, because there are certain consequences that flow from that. Evans, if a question is ambiguous, as the Supreme Court has stated, then an answer to that ambiguous question can never be perjurious. You cannot perjure yourself when you've answered a question that is ambiguous, because what the court is saying is the government understood the phrase differently from the person who was responding. So then, what is the basis for continuing with the criminal prosecution? The Supreme Court, one of the implied consequential action of assuming jurisdiction was that the perjury case should be discontinued because we did not know the meaning of owing allegiance to a country other than Ghana until Justice, what's the name of the justice who wrote the opinion?
In the Supreme Court
Yes,
case,
yes.
I mean, the name doesn't come here.
But right. Until he wrote that, Amegache, I'm sorry,
yeah.
Justice Amegache, until Justice Amegache wrote that, until Justice Amegache told us what allegiance to a country other than Ghana meant, we did not know what it means. And if we did not know what it means, then as a matter of law, a perjury claim fails, and the whole staff should be discontinued, either by the Attorney General or even the court itself.
I mean, Roxing, on that point though, isn't that why, the flip side to that isn't that why you actually then need under court of competence jurisdiction, if indeed the two sides disagree, to then pronounce on this finally? And that's why the Attorney General is in court and is saying, I want to see this through.
No, because what Prof is saying is that when you proceed to prosecute a citizen, you are bringing the entire powers of state, of the republic, against the person on founded grounds. Founded grounds means on a properly investigated matter for which a prima facie determination has been made. Because you don't go to court. This is a matter on indictment. This is a matter that's before the High Court. So indictment has been done. So to indict a person, you are saying that a prima facie determination has been made. So Prof is saying the standard in criminal prosecution is much, much higher. But it took the Supreme Court in the civil action to explain the nuances of the matter. So the state the Republic had a different understanding, represented by the Attorney General. The accused person has a different understanding, represented by himself and his lawyers. So where there's a divergence in terms of understanding of the provision, we all go to the Supreme Court. The Supreme Court says citizenship is co-terminus to allegiance. All right? So at the time, so what Prof is saying, which I am in concurrence of, is that at the time
he was filling the form, it was ambiguous.
He had no mala fide, he had no malice aforethought. He says that when you ask the question and he answers no, he did so with the intent that he owed no allegiance to neither Canada or to any other country. Now, the standard of proof in the criminal matter is much, much higher in the civil matter. So that's why I'm so worried that even with the decision of the court in the civil matter, I am surprised that the Attorney General hasn't gone back to court to amend, to vary, to withdraw his charges, and to perhaps proceed on a charge that he thinks he can succeed, but he's still proceeding in such a manner that he thinks that even the charge of perjury can be made up.
Except that is not the only charge he's pursuing. There are
exactly,
4 other charges.
Exactly my point. That's why I'm saying that when, as a lawyer, you come to this denouement, unraveling of the matters, prosecution always will come back to court and say that, with hindsight, we want to withdraw the original charge, amend it, reduce the number of charges to say 1 or 2, and refer.
So it's your view that at least a perjury should go. That's your view.
That's my view.
Yeah, but then the others then
the others
stays.
will tackle
Even
it
if your view.
matter. So we are taking the matters methodically. So as we speak, the charge in respect of perjury will fall flat.
Yeah, but you don't know that, because that is the whole essence of this particular matter.
Yes,
before the court.
We are discussing.
I get that. But for the Attorney General, he disagrees with that view, right?
And so why don't you then? It is his right to do so.
And that comes back to the question.
But we are dealing with the facts vis-a-vis the evidence.
Yeah. Well,
and we are 2 lawyers here.
It's no longer a matter of opinion.
Yes, it's a matter of law and fact and evidence.
For sure that the Supreme Court has said the phrase is ambiguous. If a phrase is ambiguous,
there is doubt.
It triggers an ambiguous question. The answer to an ambiguous question can never be the basis for a perjury prosecution, because the question is understood differently by different people. The Attorney General thinks he was asking, or the government thinks he was asking, are you a citizen of a country other than Ghana? The person say no, because he was answering a different question. So he hasn't perjured himself, because he's not knowingly providing a misleading answer to the question that you think you are asking. He is answering a different question because of his understanding of the phrase. And so this thing falls completely. I mean, I'm surprised that...
But then there are 4 other charges.
Well, most of the charges are built on this answer to,
So there's a forgery passport and travel certificate.
Yes. Let me also say this.
And then you have the deceit of public officer.
Yes.
Right? Which
all
is
based on that.
Yes.
Knowingly making false statutory declaration.
Based on that.
Yes.
And then you have, of course, the perjury one and false declaration for office.
Yes.
So, but I guess the first one is different. That is not based on a forgery allegation.
May I say this quickly? You see, the Article 94(2)(a), which is the subject of all this matter, has 3 phases. The qualification phase before you file your nominations, then the qualification phase after you file nominations and you are voted for, then the qualification phase when you are sworn into office.
Asking what happened today.
Exactly. Are you aware that today, that Honorable Quayson hasn't been sworn in? If tomorrow there's a medical report that says that he's mentally imbalanced, you have to be removed from parliament.
Yeah, well, that's what the law says, but that's not what happens in practice. Because I say that because in the same case, just before he was sworn in 2021, remember there was a case in the central region, which also became an issue.
So you see, the qualification criteria set out by the Constitution doesn't vacate from you as a member of parliament. It stays with you. Anytime there's a breach, anytime.
In fact, post the swearing in, you can still be active.
So the qualification criteria stays with you before the elections, after the elections, and after you are sworn in.
Yeah.
So anytime the checklist doesn't take, if one is missed, your qualification criteria.
So your point is?
My point is that the Supreme Court missed the opportunity to make these distinguishing factors.
But they did. And they placed it at the time of filing.
They did not. So they placed themselves at the time of filing and abandoned all the other categories.
Yeah, for them, if you have to be caught at the time of filing.
Which is wrong, because between the filing and elections, if any of the qualification criteria is not met, the Electoral Commission can disqualify you.
Let me ask you then. So you both agree that...
And also again, after you are elected, between when you are elected and before you are sworn in, if any of the qualification criteria is determined to not have been met, you can be taken out.
Yeah, you can be. I mean, that is not that the Constitution is very clear. Yes. But in this matter about allegiance, when you're filling the form, you fill the form at the time of filing. That's what the Supreme Court places there.
So the language of the Constitution.
And by the way, I've
you are not qualified to be a member of Parliament if.
Yes.
Then they state all those categories.
True. I mean, and
at what point do you become a member?
And I've made the point on this matter when, as a citizen, as a voter, I really don't want to vote for somebody only for after the person I've spent my time and queued, only for the person to go to Parliament and only to realize that he didn't qualify to be there in the first place.
But that's your choice.
As a citizen, my preference, and this is not about laws, my preference is you catch him at the time of filing, so I don't waste my time voting for him in the first place. It's not a legal argument.
It's a legal argument. It's a legal argument. That is why at the polls, you are given the choice to choose amongst or between candidates. But
that is my layman's reaction to that as a citizen, as a voter. But let me bring in the controversial subject, which is the comments. So, Prof, you've made the point that you believe, indeed, on the evidence of the Supreme Court's judgment, they should be discontinued. But it's okay if private citizen says it. But is it okay when the sitting High Court judge says it?
Well, let's be clear when we are talking about some of these things, that we stipulate the facts. So what did the judge, who's also a chief, what did he actually say?
Also a trained lawyer.
What did he actually say? If I recall correctly, he said if he was on the Supreme Court panel, he would have decided the case differently. I don't think there's anything wrong with that, because the case has been decided, and like a private citizen, he can offer an opinion on that. Many people actually agree with that supposition. And then he said he's not going to go into the reasons why he would have disagreed because of the ongoing criminal case. And then, nevertheless, he said he wants to appeal to the Attorney General to take into account public interest, public sentiment. And really, if you know anything about prosecution, there are two hurdles that a prosecutor must surmount before he brings a prosecution to court. Number one, do you think you have enough evidence to prove the charges that you are bringing? And number two, is it in the public interest to bring this matter? So that is why an Attorney General is given discretion. Not all crimes are prosecuted. You have to also think about the public interest. So for instance, how serious is the crime? What will the people think about the administrative of justice when a particular offense is prosecuted? Will the people think their resources are being used wisely or otherwise. There are all kinds of factors that one can think about. What are the mitigating or aggravating factors? In this case, you have a person who leaves Canada, applies to renounce his citizenship. He comes in, he's cleared by the Electoral Commission. There's an election, he wins, he's punished, he's injuncted from Parliament, his name is expunged. What federal public interest is served by actually prosecuting this person?
Yep.
Because on his application, which he filed in December 2019, somebody gave a response in November 2020 instead of October 2020. I mean, are we serious? Wait, Evans.
So the issue about the timelines.
The whole thing smacks like there's some vendetta. Because when you look at the facts of the case and the myriad of issues plaguing this country, the serious crimes that are being committed. Look, when the Chief Justice, the former Chief Justice, was being vetted, I recall that at that point in time, he had not filed his asset declaration. That was a constitutional violation. But common sense said, okay, let him go and fill it. He filled it, we moved on.
He actually said he has subsequently done it.
Why can't we extend?
Yeah, but then that, remember at the Musakan, they will pop up quite readily.
Please.
You know, people say, but you know, in his case, he knew it was clear he was to provide opportunity. But then they'll say, but if you want to apply the law fairly, in fact, the Supreme Court matter. When I read the judgment, the judge actually wanted
Which of them?
The one that Prof had mentioned at that site, on the subject of allegiance and citizenship.
The expulsion matter.
Exactly. It was argued there by the lead judge.
By the court.
By the court. Yes, that the parties actually failed to make that one of the, expand on the Damusa because he believed it was on all fours. Look, in this particular case.
He got it.
I mean, if
it was in that judgment. I'm sure you've read that.
Yes, I've read it. They got it wrong.
And it says it was on all fours.
We'll deal with that matter.
Anybody who thinks Adamu Sakede was on all fours with this case doesn't know what he's talking about.
Yeah.
Adamu Sakede is a friend of mine. I actually was very instrumental in his defense, which was at that time done by Justice Yoni Kolendi and Egbert Fabio.
No, at that time, lawyer Yoni Kolendi.
Yes, at that time lawyer, but now Justice Kolendi. My problem with that case was that I believe Article 94(2)A was being misinterpreted. I have the same problem now. So the only similarity between the Adamu Sakende case and the current one is that in both Article 94(2)A was being misinterpreted. But the facts are radically different.
I don't really want to focus on that. I came up, we just came up with that. No, I get it, no problem. Because but I want to go back to my original question, which is the High Court judge's pronouncement. I know you also want to chip in. But on the point that you made on that, Rule 4 of the Judges Code of Conduct.
Yes.
Okay.
And it's titled Judicial Comportment, Honor and Dignity. Prof, I put that to you before I hear from
Sure.
Hey, a judge must be the embodiment of all that is honorable and dignified. A judge must live with decorum and propriety at all times and must be reticent about cases pending in his court and generally refrain from discussing them outside court.
Yeah, well, I mean...
And you have a situation in here where a high court judge, there's one high court, there's only one high court, and he's a judge in that high court, making a pronouncement on the case that is live in the high court. Under the Constitution, there's only one high court. That clearly, surely, is a violation of the code.
Well, I mean, what you didn't read is Rule 5B, because in fairness, you should also read Rule 5B.
What does it say?
It's on avocation. It says that a judge is somebody who is learned in the law.
Thank you.
And a judge should use that knowledge to comment about matters that advance the law or justice or the administration of justice. A judge swears to uphold, defend, and preserve the Constitution. If injustice is being done, I believe a judge should come out and say, well, I think this is injustice.
Where is the injustice? It's before a court of competent jurisdiction.
Well,
how is that injustice?
Wait. Let's be sure we are not bundling issues, because the chief, in all fairness, did not comment on the case.
Thank you.
He appealed to the Attorney General.
To a public officer.
To a public officer, which he has a right to do.
Yeah, but
which we all have a right
but
to
in doing so, he's actually pronouncing on the case.
No,
he didn't believe that case is worth pursuing.
No. Here's what he said. I'm going to use my own words. He says, without prejudice to the merits of this case.
Well, he spoke in truth.
Wait. Without prejudice to the merits of the case that you are prosecuting, I believe it's in the public interest to discontinue it.
Yes, and then he says that they should terminate, file another PROSEQUI to terminate.
And what is wrong with saying that he didn't comment on the merits of the case?
But it's implied, is it not? No. What he's saying is that, in essence, like the case pending before the court in itself is not.
That's why when we started, I told you that a prosecutor thinks about two things. First, do I have the evidence? Mm-hmm. And second, regardless of the competence of the evidence, is it in the public interest to go on? There are many crimes that are not prosecuted because it's not in the public interest to do so. Either because of resources, either because it's not serious, either because people, for whatever reason. That is why attorney generals have discretion. They need to use that discretion to advance the public interest. And so there's nothing wrong with the chief saying, without prejudice to the merits of the case, I believe it's in the public interest for the country to move on. That's what he said.
Yes, you can.
Yes, Prof, thank you. Evans, the last time a NOLLE PROSEQUI was filed and actually entered by the Attorney General in this republic was in respect of the Aisha Huang case. You are aware?
I do.
Thank you.
Which was defended subsequently by the senior minister.
Thank you.
And the explanations were offered why that happened.
Thank you. So it dovetails into what Prof said, that it is in the domain of the Attorney General, pursuant to Article 88. And of course, there will be discussions at the cabinet level, that even though this matter is of public interest, but the government, which is the embodiment of the republic, is not interested in the matter. The public is interested. We were interested in Aisha Wan going to jail, being prosecuted successfully and convicted. But the persons who were exercising the executive powers of state decided that we were not, as a people, we were not interested in prosecuting her. We went to court, filed a NOLLE PROSEQUI, and entered. And Aisha Wan subsequently was deported as a result of the fact that there was no judicial proceedings pending against her. That was an exercise of the power of NOLLE PROSEQUI. And pursuant to our criminal jurisprudence, nobody questions the Attorney General how and on what basis he exercises
not entitled
the
to
power.
Explain
exactly.
Once he takes that.
Exactly. It's a question we have interrogated in constitutional law class, in criminal law class, that why an Attorney General will exercise powers such as that on behalf of all of us in the name of the state of the republic, which is bigger than the government, but our jurisprudential practices says that he owes us no explanation. Today, a noble chief says, I'm appealing to you to exercise that, and members of the bar says that he was wrong.
Yeah, but there's your view that as a judge you should have used appropriate channels.
That is why their view will not go beyond the high street in Accra.
Yeah, but if you were on the call when Ms. Samokujeto actually said that a petition should be filed.
Of course.
That could be a subject to the Judicial Council.
Now you ask Samokujeto whether he will file the petition himself. He chickened out. I was hoping that you would have filed that petition before the Judicial Council and go and defend the merits of that petition. I dare him to do so. We were in this republic when another judge of a superior elevation, not a high court, but a court of appeal, and also a paramount chief, went on a political platform and campaigned for the sitting president. The bar didn't complain. Subsequently, the chief got promoted. He went to the Supreme Court. The bar didn't complain. We were in this country when the bar president, as soon as he was elected, he went to pay a courtesy call on a flag bearer hopeful of the new Patriotic Party, Alan Tremantin. The bar didn't see anything wrong with that. I'm painting a picture. Mm-hmm. We were in this country when the bar failed to comment on the fact that a matter that was before court, but a member of parliament insults a judge, a sitting judge, in the public domain. The bar went mum. They didn't comment. They didn't say a word. We were here when a lawyer was disciplined by the disciplinary committee of the General Legal Council. He was aggrieved. He went on an appeal. A member of the Bar Association criticized the judge who reversed the decision of the General Legal Council to restoring the license of my brother Susu. The bar went mum. They didn't criticize their member for taking the judge to cleaners.
But to be fair to the bar of which you're a member, the association, they've made the point. They've made the point.
Yes.
Constantly.
Yes. And
I've spoken to them a few times about commentary and prejudicial commentary on matters before the court.
I am getting there. The comments.
Just last week they said it again.
The comments by the president of the republic, who is still a member of the bar, is the president not a member of the bar? When you went to Asim Fosu on a political platform to say that Quayson, nobody should vote for Quayson because he's going to jail, wasn't that prejudicial? The president is not above the law. So I expected my own bar association and its leadership to call the president to order in terms of the comments that he made in respect of the matter that was sub judice. The Attorney General himself, he's not a minister of justice for nothing. He's supposed to hold the scale in a balance. That even though you are prosecuting people, you are not a persecutor. So yours is to make your case pursuant to the evidence and the facts and leave the determination to the judge. But the Attorney General of this republic stood in a court of law and says that my brother Quayson was on a selfish quest and that he will be a candidate for prison.
Yeah, but that was said before a court. He's entitled to say so.
But you don't make prejudicial comments even before a court.
Yeah, but the judge didn't find anything wrong with it.
The fact that the judge didn't find anything wrong means that the judge didn't want to descend into an arena of conflict. So he himself proceeded on a path of making prejudicial comments. I saw his comments. He's issued a very lame statement today.
But that's how I want to end because we just have a minute. Okay. And I want to end on something he said in this statement.
Yeah.
And just a minute each for both of you on that. And this is a real risk of the suggestion that he should file another press on this matter. Because the Attorney General argues in this letter that the decision to prefer a charge against an accused person is not made on the basis of a person's political status. And I'm abridging. It goes ahead to say, the perception that a crime committed by a person of high political standing in society should not be prosecuted is dangerous for society and must not be countenanced. Prof, very briefly, isn't that a real risk of going ahead to file another prosecution in this matter? There's a group in society that will look at that and say, you're only doing this, one, because of the pressure, two, because he's a member of parliament, three, because he just won a by-election.
That's a red herring. I mean, you ask anybody on the street, I try to explain to my mother what the government is charging the Asin-North MP with. And my mother said, what? She could not understand it. Nobody understands what is going on. It is in the public interest to discontinue this. We've had enough. We need to move on. The 2020 elections are over. Let's move on. Let's build the country. And what are we prosecuting this guy for? I don't think it has anything to do with his status or anything like that. That's just a red herring. It has something to do with the law, and the law is that you cannot entrap people with ambiguous questions. If you ask an ambiguous question, whatever answer that you get, you accept it, and you are not going to find any court in the world send somebody to jail because you asked and you got an answer to an ambiguous question.
Briefly.
As a practitioner, under cross-examination, if as a lawyer you ask a witness under cross-examination a question that is ambiguous, as you are saying, and he gives you an answer that you are not satisfied with, and then you say that, oh, no, my lord, that's not the answer. The judge will tell you, cancel. If you don't like the answer, ask another question, because the witness has answered you. That is in practice. So all we are saying is that our client and my brother Gyakye Quayson answered the question as he best understood it on the form. In any case, between the point of filing and being cleared to be voted for on the 7th of December in an election year, who has the power to make that determination? Is it not the constitutional body of the Electoral Commission?
Well, listen, on Thursday, you've set on a floor that all of you will be going 137 of you. And then we'll see what happens in Parliament when that happens. Prof, I'm grateful that you joined us, and thank you also for joining. And as I said at the beginning, we had invited the ruling government and the MPs on the majority side to join, and we didn't get any response to that. And that's why you didn't have them on the show. But this conversation continues. We'll see what happens on Thursday.
Say that they chicken out. Don't be euphemistic.